Treaty shopping has been the buzzword for a long time in the world of international taxation. What is treaty shopping? Simply put, it involves the attempt by a person to indirectly access the benefits of a tax treaty between two jurisdictions by setting up a presence specifically for the purpose of obtaining treaty benefit. To illustrate, a US company giving loan to an Indian affiliate may suffer TDS at the rate of 15% on its interest income received from the Indian affiliate. However, it realizes that the interest on loan given by a Mauritius company suffers a TDS only at 7.5%, and any dividend distributed by the Mauritius company is exempted under the domestic laws. Thus, the US company is motivated to set up an intermediate holding company in Mauritius to route the funds to India only to obtain the lower TDS rate on the interest provided under the India-Mauritius Treaty. This undermines tax sovereignty of India, and by claiming treaty benefits available under the India-Mauritius Tax Treaty, which were not intended to be granted to a US company. This results in erosion of tax revenues to India. Question has therefore arisen whether the above structures are wrong. What was once seen as possibly a creative tax idea is now almost being frowned upon. Why is that? Much has been talked about tax avoidance versus tax planning. Historically, treaty shopping was seen as a legitimate tax planning. However, owing to challenges raised by social organization on morality of large corporations that have implemented structures resulting in nominal effective taxes, tax obligation of corporation began to also be viewed as ethical responsibility. Today, treaty shopping is associated with tax evasion or avoidance. So what has been done about this? This was one of the action items taken as part of the base erosion and profit shifting, or the BEPS project. Do let us know in the comment section below if you want us to do a separate series in detail on BEPS. The BEPS report on action item 6 addresses concerns around such kind of treaty abuse. The report recommends various mechanisms for combating treaty shopping. These recommendations are implemented through MLI. If you have not watched the earlier part in the MLI series, do watch it before you see this. The video is linked here. We have provided a conceptual understanding of what multilateral instrument is, its evolution, its construct, etc. In today's video, we will dive deep into Action 6 recommendations, which is a minimum standard under MLI. The report identifies treaty abuse, and in particular treaty shopping, as one of the most important sources of BEPS concern. In the past, OECD had taken various steps to address treaty shopping concerns, such as introducing the concept of beneficial ownership with respect to certain income, addressing issues around conduit companies, etc. However, these were found to be inadequate. The BEPS recommendation stemming from Action 6 report has been found in Article 6 and 7 of the MLI. Article 6 of MLI provides for a text of mandatory preamble to be included in all covered tax agreements to clarify their intention of entering into a tax treaty, which is to avoid the double taxation without creating opportunities for low or no taxation through tax avoidance or evasion, especially through treaty shopping arrangements. In addition to this, Article 6 also recommends for an optional preamble text which indicates the intention of countries to enhance economic relations and cooperation in tax matters through a covered tax agreement. A country willing to include this provision in its treaty should specifically express its intention in its list of position with respect to MLI provisions. What is the impact of these preamble text on Indian treaties? If you look at the list of positions deposited by India ratifying the MLI, India is silent on adoption of this article. Thus, the mandatory text of preamble, being the minimum standard, shall be added in addition to the existing preamble, and the optional text shall not be included in the India's tax treaties. In addition to the preamble, a country should adopt one of the alternatives provided under the Article 7 of MLI, namely the Principal Purpose Test or the PPT rule, or combined approach consisting of the PPT rule and a simplified limitation of benefit rule or a SLOB test. Thirdly, a limitation of benefit rule supplemented by specific rules targeting conduit financing arrangements. Based on the policy preferences of treaty partners and list of positions on reservations and notification, read with the compatibility clauses, one of these provisions shall find place in the cover tax agreement. India has opted for combination of the PPT and the SLOB. While PPT applies to large number of the cover tax agreements, SLOB will depend on other countries' preference. It may be noted that MLI does not include the detailed limitation of benefit provision as it requires substantial bilateral customization, but permits parties to opt for mutual negotiations for the detailed LOB clause. Let's understand what is PPT and SLOB to understand how these provisions tackle the treaty shopping scenarios. I have my colleague Sumana Rao here today with me. She has done extensive research and work on this area, and I'm therefore requesting her to take us through how MLI seeks to counter treaty abuse through PPT and SLOB.
The PPT rule is a broad anti-abuse rule that addresses treaty abuse, including treaty shopping scenarios, such as certain conduit financing arrangements. The text of the PPT rule reads as follows. Notwithstanding any provisions of a cover tax agreement, a benefit under the cover tax agreement shall not be granted in respect of an item of income or capital, if it is reasonable to conclude, having regard to all relevant facts and circumstances, that obtaining that benefit was one of the principal purposes of any arrangement or transaction that resulted directly or indirectly in that benefit, unless it is established that granting that benefit in these circumstances would be in accordance with the object and purpose of the relevant provisions of the cover tax agreement. The provisions of PPT have the effect of denying a tax treaty benefit to a stream of income where one of the principal purposes of an arrangement or transaction that has been entered into is to obtain a benefit under the treaty. The PPT rule is applicable in all cases except where the transaction or arrangement under the consideration is in accordance with the object and purpose of the treaty. PPT is a non-obstantive provision and should be tested despite the existence of other anti-abuse provisions such as LOB, beneficial ownership, etc. Further, certain expressions used in the PPT provision indicates that the threshold for trigger of PPT is very low. The reference to one of the principal purposes means that obtaining that benefit under a tax treaty need not be the sole or dominant purpose of a particular arrangement or transaction. It is sufficient that at least one of the principal purposes was to obtain the benefit. Thus, it makes PPT provision broader than the GAR under the Income Tax Act, which contains a main purpose test. In other words, if it can be established that one of the principal purposes of the transaction or the arrangement is to obtain tax benefit under the treaty, the access to the treaty can be denied. Secondly, PPT rule is triggered where it is reasonable to conclude that one of the principal purposes of the arrangement or transaction was for obtaining a benefit under a tax treaty. It is not necessary for the tax authorities to find conclusive proof of the intent of a person concerned with an arrangement or transaction, but if it is reasonable to conclude, after an analysis of relevant facts and circumstances, that one of the principal purposes of the arrangement or transaction was to obtain the benefit of a tax treaty, to apply PPT. This leaves the obligation to show the legitimacy of a transaction with the taxpayer. The terms arrangement or transaction should be interpreted broadly and include any agreement, understanding, scheme, transaction, or series of transactions, whether or not they are legally enforceable. In particular, they include the creation, assignment, acquisition, or transfer of the income itself, or of the property or right in respect of which the income accrues. These terms also encompass arrangements concerning the establishment, acquisition, or maintenance of a person who derives the income, including the qualification of that person as a resident of one of the contracting states, and include steps that persons may take themselves in order to establish residence. The term benefit includes all limitations on taxation imposed on the source of state under Article 6 through Article 22 of the treaty, the relief from double taxation provided by Article 23, the protection afforded to residents and nationals of a contracting state under Article 24 or any other similar limitations. As we have already noted, PPT rule has an exception. The onus of proving that obtaining the treaty benefit is in accordance with the object and purpose of relevant provisions of a treaty lies with the taxpayer so as to trigger the exception to the PPT rule. Object and purpose of a treaty as a whole or the relevant provisions of a treaty can be availed in the text of the treaty itself, including its title and preamble, the context of the treaty, say the backdrop in which particular provision was inserted, commentaries to the model convention indicating the intention of particular provisions, and other source of treaty interpretation. PPT is very broad and therefore there is likely to be apprehension that it would be applied even in case of legitimate transactions. Para 182 of the 2017 OECD commentary on PPT enlists 13 examples illustrating the application of the PPT rule, where arrangements are entered into with a business consideration such as expanding the business, availability of requisite infrastructure, or constituting a real business activity by exercising substantive economic functions using real assets, assuming real risks, or results in obtaining treaty benefits in accordance with the general objective of encouraging cross-border investment or obtaining that benefit legitimately. Treaty benefits cannot be denied under the PPT rule. However, arrangements which result in no or low taxation in source state by treaty shopping or by artificially assigning debt, dividend, etc. without any other objective, or which result in artificial avoidance of P status by splitting up of contracts, artificially shifting poem to establish substance which is different than the actual form, PPT rule will be triggered and treaty benefits are denied. In our earlier example, we saw that an SPV was interposed merely to obtain lower TDS rate under the applicable DTAA. In such case, PPT shall be triggered and the benefit of lower TDS shall not apply. As against that, if the SPV has business reasons for its establishment in the tax favorable jurisdiction and obtaining lower TDS rate is only an incidental benefit, then PPT shall not apply. The simplified LOB article is anti-abuse provision targeting specific abuses or forms of entities indulging in abuse. Under SLOB, a person who is a resident of a contracting state should satisfy the alternative test provided therein. SLOB is an optional standard and included in a cover tax agreement only if both the countries have agreed to opt for it. For example, India has opted for SLOB, whereas UK has opted only for PPT. In such a case, since UK has not specifically opted for SLOB, India-UK DTAA will not have SLOB and will have only PPT. However, it may be noted that Russia has opted for PPT plus SLOB, and thus India-Russia treaty will be modified to include PPT plus SLOB. Countries have the option to adopt SLOB only with respect of certain treaties where the other treaty partner has opted for it, either symmetrically or asymmetrically. For example, Denmark has agreed to opt for SLOB symmetrically. Thus, India-Denmark treaty will be modified to include PPT along with SLOB, whereas other treaties of Denmark may or may not include SLOB, subject to other countries' choice. On the contrary, Greece has agreed for asymmetrical application of SLOB. Thus, India will apply PPT plus SLOB to grant treaty benefits under India-Greece treaty, and Greece will apply only PPT to grant treaty benefits. It may be noted that satisfying SLOB will not automatically entitle a taxpayer to a tax treaty benefit. A taxpayer is additionally required to satisfy other treaty SARs and PPT. Now, let's understand each of the conditions needed to be tested under the SLOB test. A resident should be a qualified person. Some of the categories of residents automatically satisfy the definition of qualified person, namely individuals, government and governmental bodies such as local authorities, etc., publicly traded companies or entities, non-profit organizations or pension funds. However, the QP test provides certain ownership criteria for entities which are not covered in the above list. As per this test, an entity shall satisfy to be a qualified person if at least 50% of the shares of that entity is held directly or indirectly by the residents of the same country for at least half of the days of 12-month period preceding the date on which treaty benefits are applicable. Irrespective of whether a resident is a QP or not, a resident can still be eligible for treaty benefits if such person is carrying on active trade or business in its country and the income emanates from or is incidental to that business. A person is not considered to be engaged in active trade or business if it's an operating holding company, providing overall supervision or administration of a group, providing group financing, etc. In respect of passive incomes, in the nature of dividend, interest, royalty, FDS, etc., where a resident does not qualify to be a qualified person, treaty benefits may still be granted if the derivative benefits test is satisfied. According to this test, if on at least half of the days of any 12-month period ending on the day of granting of benefits under a cover tax agreement, at least 75% of beneficial interest is directly or indirectly owned by certain persons entitled to equivalent benefits. Logically, the treaty benefits will be granted to a resident only if the owner of that resident would have been entitled to at least same benefits had the income in question flowed directly to that owner. To illustrate, consider a case where there is a back-to-back loan arrangement from TCO to RCO and RCO to Indian Co. TDS rate on interest paid by India Co to RCO is 10% and TDS rate for onward payment to TCO is nil, either due to domestic law of state R or treaty between state R and state T. In this case, TCO is considered as equivalent beneficiary of interest income if a hypothetical direct payment of interest from India Co to TCO would have suffered equal or lesser TDS. Since 100% of RCO is held by TCO, an equivalent beneficiary, derivative benefits test is satisfied and treaty benefits shall be granted to RCO. Discretionary relief by competent authority. A competent authority can grant certain treaty benefits where benefits would have otherwise been denied under the above rules, taking into account the object and purpose of a CTA and after examining the principal purposes of the transaction. Thus, as per India's choice, where the PPT and SLOV conditions are satisfied, India will grant a treaty benefit under the applicable treaty.
Thank you, Sumana. That was very insightful. Apart from the language change to the preamble, the PPT and the SLOV, are there any other relevant clauses in MLI that seeks to counter treaty abuse?
Yes, Vaishaka, there are certain optional standards prescribed by Action 6 report for tackling specific forms of treaty abuse. These provisions find place in Article 8 through Article 11 of MLI. Article 8 addresses the abuse of beneficial tax treatment given under the tax treaties for dividend income in case of minimum shareholding in the company distributing the dividend. For example, Article 10.2 of India-Canada Treaty provides that the source country may tax dividend paid by a company resident therein, and the tax rate on such dividend is 15% if the recipient, being a beneficial owner, owns at least 10% of the shares of the company paying the dividend, and 25% in other cases. How can this provision be abused? If Canada company holds 10% only on the date of payment of dividend, merely to obtain beneficial treaty rate of 15%. How is this abuse addressed by Article 8 of MLI? It recommends countries to include a minimum holding period of 365 days before the day on which dividend is paid. It also recommends countries to include an ownership threshold of 50% as against 10% under India-Canada Treaty above. However, this being an optional provision, it shall apply only if both countries opt for it. India has opted for this provision. Thus, an additional condition is applicable to indicate that the 15% tax rate shall apply only if the ownership condition described in those provisions are met throughout a period of 365 days that include the day of the payment of the dividends. Except for its treaty with Portugal, India has notified 21 treaties to include this provision, subject to other treaty partners' position. This provision assumes more importance in light of abolition of DTAA. As per Article 13.4 of the OECD commentary, gains derived by a resident of a a contracting state from the alienation of shares deriving more than 50% of their value directly or indirectly from immovable property situated in the other contracting state may be taxed in that other state. For example, FCO2 has 100% shareholding in FCO1. FCO1 shares value is wholly or almost wholly derived from immovable property situated in India. FCO2 proposes to transfer shares of FCO1. This transaction would attract tax in India if the applicable treaty contained a provision similar to Article 13.4 of OECD Model Convention. It may be noted that this provision applies only to alienation of shares in a company and could be abused where FCO1 is organized as a partnership or a trust or any other form of entity. Further, the provision can be abused by selling the immovable property just before the sale of FCO1 shares. Thereby, FCO1's value is not derived from immovable property situated in India on the day when FCO1 shares are transferred. Article 9 addresses misuse of this provision based on Article 13.4 of OECD MC by expanding the ambit of the section to interest in any entity and by giving a look back period of 365 days, that is, source country taxation applies even if value is derived from immovable property on any day in 365 days before the date of transfer. Further, as an option, countries can also include a value threshold of 50%, thereby agreeing for source taxation if the immovable property sums up to 50% of the value of the company whose shares are transferred. This again is an optional provision. It shall apply only if both countries opt for it. India has opted for this provision and notifies 71 DTAAs to include look back period of 365 days and 50% value threshold, subject to treaty partners' position. For example, Article 13 of India-Canada Treaty is modified to include a para to state that gains derived by a resident of a contracting state, say Canada, from the alienation of shares or comparable interests, such as interests in a partnership or trust, may be taxed in other contracting states, say India, if at any time during the 365 days preceding the alienation, these shares or comparable interests derived more than 50% of their value directly or indirectly from immovable property situated in India. Other two optional provisions are Article 10, which addresses abuse of tax treaties in triangular situations. Certain MNEs establish PE in a third state, which is normally a low tax jurisdiction, thereby eroding tax base of source state as well as resident state. This BEPS concern is addressed by denying treaty benefit by source country if the income paid to an MNE is attributed to third country PE, wherein the tax rate is less than 60% of the tax imposed in resident state if there was no such PE, and due to such attribution of income to a PE, such income is not taxable in resident state. Article 11 seeks to address an argument according to which the tax treaty impairs rights of a country to tax its own residents. In other words, it provides for a savings clause which preserves the right of a contracting jurisdiction to tax its own residents subject to certain exceptions. Additionally, Article 11 also ensures that certain benefits granted to tax residents are not impacted. These provisions find their origin in US models and US treaties. India is silent on these provisions. As these provisions are optional provisions, a question arises whether silence indicates adoption of this provision by India. The answer seems to be yes, since India has not made any reservations for excluding these provisions, and also the compatibility clauses of these provisions indicate that the provision shall apply in the place of or in the absence of an existing provision of a treaty. However, one should check for the other country's position to determine the applicability of these provisions in a covered tax agreement.
That was indeed a very good brief on the issue, Sumana. That brings us to the end of this module. In this module, we got a broad overview of how recommendations of BEPS Action 6 report are included in the MLI and what impact these provisions will have on the India's treaties based on India's position list. To reiterate, preamble and PPT are minimum standards and shall mandatory apply to all signatories of MLI unless they opt for bilateral negotiations. Other provisions are optional standard and shall apply only if both the countries opt for it. You may leave your questions and feedback in the comment section below. Also, Do let us know if you'd like us to do a detailed video on the above provisions. In the next module, we will look at BEPS report on Action 7, that is Prevention of Artificial Avoidance of PE. Thank you so much for watching. We will see you in the next video.